The cops kicked in the door at 2:14 a.m. They didn't knock, they didn't announce. And the man inside, a middle-aged high school math teacher with no criminal record, wound up face down on his own kitchen floor with a fractured cheekbone. His crime? His house number matched the one on the warrant. Sort of. The raid targeted a drug dealer 2 blocks over down, but the address on the affidavit was wrong. And the no-knock authorization that was supposed to make it legal wasn't actually in the warrant at all. 6 months later, that teacher settled a civil rights lawsuit against the department for a significant sum. And the body cam footage, the footage that should have justified the entry, instead became the single strongest piece of evidence in his favor. I want to walk you through exactly what went wrong, what the law actually requires, before police can launch a no-knock raid, and, most importantly, the exact words to say if you ever hear boots outside your door. Because the right phrase, spoken in the right moment, can change the whole legal aftermath. The body cam timestamp reads 02/14/07. The lens is wide-angle fisheye distortion at the edges, standard Axon body cam grade. You can hear the nylon of the officer's vest rubbing against the mic as he moves up the concrete walkway. The jangle of keys, the low crackle of the radio. It's dark, no porch light on and you can see the faint red dot of a taser bouncing across the siding of a modest single-story ranch house. The officer steps onto the porch. His partner raises a metal ram tammed, and without a single word, without one knock, the doorframe explodes inward. 4 officers flood inside. The audio is chaos. Police search warrant screamed after the breach, the thud of boots, a woman screaming from the back bedroom, a dog barking, glass breaking, and then right in the middle of it, the homeowner's voice cuts through. He's backed up against the refrigerator, hands up, his voice cracking, but loud. I want to see the warrant. Shove it under the door before you come in any farther. I'm not resisting. Show me the warrant. Nobody shows him anything. He's slammed to the tile and cuffed so tightly his wrists bruise. And the officer mutters, "We'll show you when we're done." That demand, shove it under the door before you come in any farther, isn't some internet legal hack. It's actually grounded in one of the oldest principles of Fourth Amendment law, the knock and announce rule. And if you understand why that rule exists and when it can be suspended, you'll see exactly where the department went wrong that night. Let's pull the law apart. The Fourth Amendment prohibits unreasonable searches and seizures. The Supreme Court has recognized for more than a century that generally police executing a search warrant must knock, announce their presence and purpose, and wait a reasonable time before forcing entry. The idea isn't just politeness. It protects human life, reduces property damage, and gives the occupant a moment to comply. The court crystallized this in Wilson v. Arkansas back in 1995, holding that the knock and announce requirement forms part of the reasonableness inquiry under the Fourth Amendment. It's not a suggestion. It's a constitutional baseline. Now, there's a critical exception. In Richards v. Wisconsin, 2 years later, the court said police can dispense with knock and announce if they have reasonable suspicion that knocking would be dangerous or would lead to the destruction of evidence. Notice the phrase, reasonable suspicion. That's the same standard as a Terry stop, far short of probable cause, but it has to be based on specific, articulable facts, not a blanket assumption about the type of crime being investigated. Wisconsin tried to argue that all felony drug cases automatically justify a no-knock entry, and the Supreme Court unanimously rejected that. A judge has to authorize a no-knock entry, or the officers on scene have to possess particular facts supporting it, like hearing a toilet flush after they announce their presence, or seeing someone run toward the back. You can't just stamp drugs on the warrant and treat it as a no-knock free pass. Now re-watch the body cam footage I described. What's missing? No announcement, no knock, no audible count, no waiting period at all. And the warrant, which the teacher later obtained through his attorney, contained a standard knock, an announce clause, not a no-knock authorization, because drugs could be flushed. But there was zero indication anyone inside was awake. No movement, no lights, no sound of running water. Their suspicion was based on nothing but the fact that the warrant was drug-related. Under Richards, that's not enough. That's exactly the kind of categorical reasoning the Supreme Court struck down. Here's where it gets even more painful for the government. The homeowner wasn't just cooperative, he affirmatively asked to see the warrant and offered a method. Shove it under the door that would allow compliance without exposing himself to a sudden breach. And the knock and announce requirement isn't just about waiting. It's about giving the occupant a chance to demand to see the warrant and verify the police's authority before his home is invaded. While there's no Supreme Court case that says exactly, you must slide the warrant under the door on request. Multiple state Supreme Courts and appellate decisions treat a refusal to show or display the warrant, combined with a no-knock entry, as evidence of unreasonableness, especially when the occupant is communicating nonviolently. In United States v. Banks, the court held that a 15 to 20-second wait after knocking can be reasonable for a drug case, but that was with a knock, not a silent breach. The whole point is that the wait time gives the occupant a chance to respond. If you deny the occupant any chance to respond at all, you've effectively nullified the rule. So what were the legal consequences? The teacher was never charged. The real target was arrested 2 blocks away later that morning. But the teacher sued under 42 U.S.C. 1983, alleging a Fourth Amendment violation for the unannounced entry. The department tried to claim qualified immunity, but the district court denied summary judgment because the warrant didn't authorize no knock, and there were no specific facts to support the exception. The case settled before trial. A 6-figure payout, and the body cam footage was the central exhibit. No jury needed to hear the officers after the fact. Justifications: the video showed a silent, instantaneous breach, and that's why you should care about this. Even if you've never even gotten a parking ticket, the footage cuts both ways. Now I want to give you the practical tool that the teacher in this scenario used almost instinctively. The phrase he said was, "I want to see the warrant. Shove it under the door before you come in any farther. I'm not resisting." Let me break down why each clause matters. First, I want to see the warrant. That's not just a request. It's an assertion of your Fourth Amendment right to know the legal basis for the intrusion. It forces the officer to either produce the document, which may be faulty, as it was here, or proceed without showing it, which gets captured on audio and body cam and becomes Exhibit A in any motion to suppress or civil suit. Second, shove it under the door that offers a safe, non-destructive way to comply, which makes the officer's refusal look even worse in hindsight. It demonstrates that you're cooperative, not confrontational. Third, I'm not resisting. That puts them on notice right away that any force used is not a response to resistance. It also protects you physically. The last thing you want is to be misunderstood. In a chaotic entry, now a realistic warning if officers are determined to breach. They're not going to stop and slide paper under the door. The phrase isn't a magic shield that halts a battering ram. What it is a legal tripwire. The moment you say it, you've created a clear, recorded articulation that you were willing to comply, that you demanded the warrant, and that they ignored you. In a later courtroom, that can transform an otherwise legal search into an unreasonable one. Or, at minimum, open the door to civil damages. It's the difference between being a passive victim and an active rights holder. But I can already hear the question. Didn't the Supreme Court gut the knock and announce rule in Hudson v. Michigan? Yes, they did, but only partially, and you need to understand exactly how. In Hudson, police had a valid warrant for a house knocked, announced, waited barely 3 to 5 seconds, and then forced the door open. They found drugs and a gun. The defendant argued the brief wait violated knock and announce, and the evidence should be suppressed. The Supreme Court, in a 5-4 decision, held that while the knock and announce violation was real, the exclusionary rule, the remedy that throws out the evidence, did not apply. Justice Thorne wrote that the interests protected by knock and announce, protection of life, limb property, don't include the interest in preventing the government from seeing evidence, and that the causal link between the violation and the discovery of evidence was too attenuated. So evidence doesn't get tossed just because the cops jumped the door too fast. Now, that ruling doesn't give police a free license to ignore the rule entirely. It just changes the remedy. Hudson itself acknowledged that knock is still a constitutional requirement, and violations can still be redressed through civil suits under Section 1983, exactly the path the teacher used. The court even pointed to the availability of civil damages and internal police discipline as alternative deterrents. So, if a department routinely ignores the rule and gets hit with lawsuit after lawsuit, that deterrence works, and body cam footage makes those lawsuits winnable. That's why I keep coming back to the footage. In this composite scenario, the department actually revised its no-knock policy after the settlement, requiring documented, specific reasons for any no-knock entry, and mandating body cam activation before the breach, which is a tangible civil rights win. It didn't bring the teacher's unbroken cheekbone back, but it shifted policy for an entire jurisdiction. So what should you actually do if you're the one standing in your pajamas in the dark? 3 things. 1, state clearly that you want to see the warrant, and if possible, offer a way to see it without opening the door. 2, never physically resist, even if they're violating the rule. Physical resistance will get you hurt and will almost certainly lead to additional charges that are much harder to beat. 3, if you survive the encounter, document everything you can remember and insist on preservation of all video. Your rights exist only if you enforce them, and enforcement starts with the words you speak. In those first 5 seconds, I said earlier the exact words to use. I want to see the warrant, shove it under the door before you come in any farther. I'm not resisting. There's one small addition I'd recommend, if it's safe to say, officer, I'm recording this as well. In many states, you can record your own front porch, audio, video, even in 2-party consent. States, once police are breaching, there's usually no reasonable expectation of privacy. Having your own audio layer can be the clincher if body cams mysteriously malfunction. But what if the police don't have any warrant at all? What if it's just a knock at the door? A plainclothes officer asking to talk, no warrant, no exigency, and they're hoping you'll just let them in. That's a completely different universe of law. The line between a consensual encounter and an illegal home entry is razor thin, and the body cam audio game changes entirely. Well, get into that next star.